you've had a change in a personal relationship or just gotten to a point in a relationship where you're saying to yourself and to anyone who will listen, enough is enough and I can't take this anymore, you may be looking at pursuing some kind of court case for a divorce, or to establish custody, or to set up a parenting plan, or just to modify some judgment that's already in place. And if you're looking to stand up for what you think is in your best interest or in the best interest of the children, it's very common to wonder, well, what's next? As a divorce and family law attorney, I am routinely asked, what does this process look like and what steps do I need to take? Well, these videos are intended to provide a quick summary of some of the steps of a divorce or family law case in Oregon. Now, while you're watching these videos, you should keep in mind that they do not cover everything that may need to be done in a case. Also, these steps can overlap with one another, they can go out of order, and some of them can even be skipped entirely at times. So working with an attorney who is familiar with the issues in family law court can help you through any and every step of this process. A divorce or a family law case in Oregon officially begins when one side files a petition or a motion with the court asking the court to make a decision on some issue. That can include asking for a divorce, asking to establish custody, asking for a legal separation, or modifying an existing judgment, or some other kind of relief. I usually describe this part of the process as someone asking the court to do something for them or to give them something. Once those documents are submitted to a court and approved by the court, the person submitting them will then have to have the other party served with those documents. Once the party is served, they have a period of time within which they need to file a response. The response is just what it sounds like, the other party responding to the petition or motion and saying, I agree or I disagree with what they're asking the court to do. Now, there are some exceptions, there's some rules that can make this a little bit more complicated, so you should definitely consult with an attorney if you need help with the process. Between the time that a case is initiated and a final trial or hearing is scheduled, there are a number of issues that can come up. So the law provides parties with the opportunity to ask for all sorts of temporary orders that will set rules for the parties to follow while they're waiting for that final trial or hearing. That can include asking for temporary custody or a temporary parenting plan. It can include temporary financial support, exclusive use of a home or a vehicle, or some kind of emergency protection for children who are in danger, or it can be orders asking one side to not move away with the party's children. Really, any issue where the parties may not want to wait or may not be able to wait until a final trial, they can file one of these motions and ask the court for temporary relief. Now, pursuing these kinds of motions could involve potentially appearing at a hearing, and that can make the whole process somewhat expensive and time-consuming. So it would be a good idea to discuss any of these kinds of motions with an attorney before you commit to pursuing them. After a case is initiated and before a final hearing, the parties have the opportunity to gather and request documents, to speak with witnesses, and assemble any kind of information that will help them prepare to present their case at a final hearing. This discovery process can include requests for production of documents where the parties are asking each other to provide documents and information about issues related to the case. It can include scheduling depositions where someone is sworn to tell the truth and then asked a series of questions that are related to the case. It can include working with experts who will provide testimony, who will write reports and opinions that may be helpful to the court. Now, not all of these things may be helpful or even necessary in every case, and there can be consequences for not gathering discovery that you need or that is requested of you. So it's a good idea to work with an attorney during this part of your case to make sure that you're covering all of your bases. Now, once a party feels that they have enough information, they may want to propose some way to resolve the dispute. Again, the steps of this process don't always follow a specific pattern, and settlement discussions are certainly no exception to that. They can really take place at any point and any time during the process. That can be through a formal mediation, it can be through sending a letter, it can be through emails or a phone call, or even at the courthouse right before the trial. Coming to a reasonable resolution and settling the issues in your case without having to put all of the issues before a judge can save parties a lot of time, money, stress, and it can allow them to have a lot more control over their future. So if you're at a point where you think you would know what you would like to propose to resolve the matter, it's a good idea to work with your attorney to get that proposal put together and sent over to the other side. If the parties haven't been able to reach an agreement or resolve their dispute, they may have to go through a trial or hearing. A trial, each side has the opportunity to present evidence. That can include presenting documents, it can include having people testify, presenting witnesses, having experts provide opinions or reports that may be helpful to the court, and then making arguments to the court where you're trying to convince a judge to accept your position and make a ruling, giving you what you are asking for. Trials can be very stressful. There are a lot of rules, there are expectations of the parties, and there are restrictions on both sides that everybody is expected to follow when they're presenting information to the judge, who will be making decisions about issues that are very important to the parties. So if you're facing the possibility of having to go to a trial or a hearing, working with an attorney can be extremely important to make sure that you are putting your best foot forward. After an agreement has been reached or a court has issued a final ruling, that agreement or ruling needs to be committed to a written judgment. Judgment is the final document that dictates the outcome of the dispute and the rules that the parties are expected to follow going forward. When there are attorneys involved, one side usually prepares the judgment and has to give the other side the opportunity to review the judgment and make any objections. Drafting the judgment and exchanging objections, it can be a bit of a process. And on top of that, the judgment is almost certainly the most important document in a case. So it's certainly a good idea to work with an attorney to make sure that the judgment in your case is correct. So that is a very basic summary of the different steps in a divorce or family law case. And again, you should keep in mind that the steps don't always flow in that order, and some of the steps may be skipped entirely. So if you're facing a divorce or family law case, working with an attorney can help make sure that that process is as smooth and efficient as possible. And the attorneys at our firm would be more than happy to help you with that process.